You've probably heard it 100 times on TV or in the news. The jury must find the defendant guilty beyond a reasonable doubt. What does that actually mean? Does the jury have to be 100% sure? And what counts as a reasonable doubt versus a random what if or possibility? So these questions are at the heart of every criminal trial because this is the highest burden of proof in our entire legal system. Now let's say you're sitting on a jury in a Florida courtroom. You've heard all the witnesses, seen all the evidence, and now the judge tells you, you must be convinced of the defendant's guilt beyond a reasonable doubt. Well, that sounds simple, doesn't it? But it's not always easy to know what that means in practice. It doesn't mean 100% certainty. It doesn't mean beyond all doubt at all. It means the evidence is so convincing, so solid, that no reasonable person would hesitate to make the same decision. So to put it plainly, beyond a reasonable doubt means the jury must be firmly convinced that the defendant is guilty. If there's a logical, evidence-based reason to doubt guilt, the jury must vote not guilty. But if their only doubts are far-fetched or based on speculation or guesswork, then they should cast a guilty verdict. So a lot of times visuals help really explain and hammer this home. And so we use this chart to show the jury in trials exactly how high proof beyond a reasonable doubt is. So if you think somebody's guilty, probably guilty, possibly guilty, guilt is likely, all of those scenarios, the jury must return a verdict of not guilty. The only way, the only way a jury can find somebody guilty is if it's guilt beyond and to the exclusion of every reasonable doubt. Let's start with an example of a doubt that doesn't count. Imagine there's DNA evidence, surveillance video, multiple eyewitnesses identifying the same person. And a juror says, well, maybe the lab tech was part of a secret conspiracy to frame him, but there's no evidence of it. Well, that's not reasonable. That's an imaginary doubt, a story with no real proof behind it. Courts call that a possible or speculative doubt, not a reasonable one. But now let's consider a realistic or reasonable doubt. In another case, the video footage is blurry. The witness admits they only saw the suspect for a split second in the dark. And a juror thinks, I'm not firmly convinced this is the right person. Well, that is a reasonable doubt. It's based on weak evidence in the case, not wild theories. Reasonable doubt comes from three main things. 1, problems with the evidence. 2, a lack of evidence. And 3, conflicts between the different pieces of evidence. The high standard exists for one reason, fairness. In our justice system, the stakes are enormous. Someone's freedom, future, reputation, they're all on the line. So the law leans towards protecting the innocent, even if it means some guilty people go free. It's based on the principle, it's better for 10 guilty people to go free than for one innocent person to be wrongfully convicted. And I would say it's better for 100 guilty people to go free rather than one wrongfully person convicted. That's what beyond a reasonable doubt is really about. It's making sure that we're certain enough before we take away the most valuable thing that we can from somebody, which is their freedom, their liberty. Think of it like this. Reasonable suspicion is noticing smoke. Probable cause is seeing the flames. Beyond a reasonable doubt is standing in front of the burning house, watching your neighbor with a can of gasoline and a lighter in his hand. At this stage, the facts should leave almost no reasonable explanation other than guilt. During deliberations, jurors go back over everything they've heard. Testimony, exhibits, expert opinions, inconsistencies, all of it. They don't vote based on sympathy or emotion. They vote based on whether the evidence erased every reasonable doubt. Sometimes they'll rewatch videos, reread transcripts, ask for clarifications from the judge. And if they finally reach a guilty verdict, it means they've crossed that very high bar. Let's go into some common misunderstandings. Many people think the defense has to prove that the defendant didn't do it, that I have to prove my clients are innocent. But that's not true. In a criminal law, the burden always stays on the government, either the state or the United States government. The defense doesn't have to prove anything. We just have to point out holes, contradictions, or missing pieces that create doubt. And remember, no one has to prove innocence. It's the state's job to prove that our clients are guilty beyond and to the exclusion of every reasonable doubt. Now, no system is perfect. There's almost always some doubt. No case has 100% certainty. So when we say beyond a reasonable doubt, we mean no reasonable doubt based on the evidence. It's the highest bar we can realistically reach without demanding absolute proof, which never exists in real life. So how can this play out in real life Florida courtrooms? Imagine a robbery case. The prosecution shows a grainy video and a witness says, I think it looked like the defendant. But the defendant's fingerprints aren't on the weapon. And the defendant has an alibi, and that alibi checks out. Well, there's doubt. There's real reasonable doubt. Even if the jury feels like he might have done it or he probably did it, the law says that's not enough and you must find him not guilty. And this high standard is what keeps people believing in the fairness of the system. It's what separates justice from punishment based on fear, bias, or emotion. When juries apply it correctly, it protects all of us. Because one day, any of us, me and you, could be the person sitting at the table that needs the benefit of that doubt. So here's where we are in the pyramid of proof. Reasonable suspicion means police can stop and question. Probable cause means police can arrest or get a warrant. Beyond a reasonable doubt means that prosecutors must prove your guilt in criminal court at a trial. Those are the three standards of proof for the criminal justice system. But it's not the end of every story, because not every case is criminal. But what happens in civil cases where no one's facing jail, but maybe there's money, reputation, or a restraining order on the line? The rules change and the standard drops way down. And in the next video, we're going to explain preponderance of the evidence. It's a lower burden that's used in lawsuits, civil cases, restraining orders, and why it only takes a small tip of the scale to win your case.